For many, many years, the Jewish community was running a private arbitration center called the Beis Din, where Orthodox Jewish people, upon separating, would go before the head rabbis, and the head rabbis who understood the sort of community that they lived, the sort of lifestyle that they led, and of course recognized the law that applied to that particular group of people. The rabbis in the Beis Din would apply their rules of law to an Orthodox Jewish family splitting up. When McGuinty got wind of the fact that the Muslim community was planning to do the same thing, there was an outcry from a very large lobby group on behalf of Muslim women saying, we don't want that, that's going to be prejudicial to us, and as a result, McGuinty kiboshed the notion of Islamic private arbitrations.
Was it successful in the Jewish faith, the Jewish community?
I believe so. I believe it was successful because for those people that did not want to go to the Beis Din, they still had the Ontario courts to go to.
Okay.
But at least they had the ability to fulfill their own sense of moral and religious duty by going before their own religious cleric. And so it worked. There were really no significant complaints about it within the Jewish community, but along came the Muslim community wanting to do the same thing, and it wasn't permitted. And as a result, there was a whole series of new laws that came into effect in 2007 that dealt not just with religious private arbitrations, but also with all forms of secular family law arbitration, so that now we have a lot of rules that pertain to people, you and I. If we're going through a divorce and we want to use an arbitrator, we have all of these new laws, which to some extent are fantastic because it protects people, but this is all as a result of events that had occurred outside of the real issue of private family law arbitrations.